Today we'll be discussing what alternate visas are available if your employee is not selected in the H-1B visa lottery. But first, Jacqueline, could you provide an overview of the H-1B visa program?
Sure, Carmen. The H-1B visa program allows United States-based companies to employ foreign workers for occupations that require highly specialized knowledge. These workers must possess a bachelor's degree or higher in a specific specialty related to the position or its equivalent. There are currently 85,000 H-1B visas available every fiscal year. The United States Citizenship and Immigration Services, or USCIS, conducts a randomized H-1B cap lottery each year to select visa beneficiaries. Foreign nationals that are not selected in the H-1B cap lottery are not eligible to receive an H-1B visa for that fiscal year. However, they may qualify for other non-immigrant visa categories, which we will discuss here today.
For starters, foreign nationals who are not selected in the H-1B lottery may be able to work as a dependent of their spouse's H-1B or L-1 visa. How does this process work, Jacqueline?
A foreign national who lacks legal immigrant status can apply for H-4 or L-2 status if their spouse is a current H-1B or L-1 visa beneficiary. Individuals on L-2 status can apply for an employment authorization document or an EAD without employer sponsorship, which enables them to work for any employer. Individuals on H-4 status can only apply for an EAD if their H-1B holder spouse is the beneficiary of an approved I-140 petition. H-4 or L-2 visas are tied to the spouse's H-1B or L-1 visa, which means they are only valid if the principal visa is valid. H-1B visas are valid for up to 3 years, with possible extensions of up to a maximum of 6 years. L-1 visas are valid for 3 years for initial requests and 2-year periods for subsequent extensions. L-1B visas are valid for a maximum of 5 years, while L-1A visas are limited to a total of 7 years. Individuals under H-4 or L-2 status who work with a valid EAD may be sponsored for a green card by their U.S. employer under any of the employment-based categories.
Individuals who entered into the H-1B visa lottery may also qualify to be sponsored on an L-1B visa. Could you provide some insight on L-1B visas and who qualifies for them, Jacqueline?
The L-1B visa allows a U.S. employer to transfer an employee with specialized knowledge that relates to the organization's business from an affiliated foreign office to its U.S. office. The employee must have worked for the foreign office utilizing their specialized knowledge for at least 1 year within the last 3 years. These employees are granted an initial stay of 3 years. A foreign company can also use this visa to send an employee to work at a new U.S.-based office. L-1B employees will be allowed a maximum initial stay of 1 year if working at a new office. Extensions may be granted in increments of up to 2 years until the employee has reached the maximum limit of 5 years.
The L-1A visa offers another option to skilled intra-company transferees to work in the United States. What does that visa category entail, Jacqueline?
This visa allows a U.S. employer to transfer an employee from an affiliated foreign office to the U.S. office to work in a managerial or executive capacity. The employee must have worked for the foreign office as a manager or executive for at least 1 year within the last 3 years. These employees are granted an initial stay of 3 years. A foreign company can also use this visa to send a managerial or executive employee to initiate a new U.S.-based office. Beneficiaries will be allowed a maximum initial stay of 1 year if initiating a new U.S. office. Extensions may be granted in increments of up to 2 years until the employee has reached the maximum limit of 7 years. Individuals who qualify for L-1A status may also be sponsored for a green card by a U.S. company under the EB-1C employment-based category.
Thanks for the overview, Jacqueline. Individuals with extraordinary ability may consider the O-1 visa category. Which individuals qualify for this visa?
An O-1 visa is granted to individuals that demonstrate extraordinary ability in the sciences, arts, education, research, business, or athletics. Additionally, it can be granted to those who have demonstrated extraordinary achievement in the motion picture or television industry. All O-1 applicants must demonstrate that they have been recognized nationally or internationally for their achievements. O non-immigrants can be admitted to the United States with an initial stay period of up to 3 years, plus a period of up to 10 days before the validity period begins, and 10 days after the validity period ends. These beneficiaries are only authorized to work during the validity period of the petition. Individuals who qualify for an O-1 visa may also qualify for a green card under the EB-1A or EB-1B employment-based categories.
The J-1 exchange visitor visa may be available to certain professionals that also qualify under H-1B. Jacqueline, could you please shed some light on the J-1 visa program?
Sure, Carmen. Certain jobs that qualify for an H-1B visa are also fit for sponsorship under the J-1 exchange visitor visa. Some of these roles include professors and research scholars for periods of 3 weeks to 5 years. This period can be repeated after a 2-year residency outside of the United States. Physicians for up to 7 years, trainees for 3 weeks to 18 months. Individuals may repeat this period after residing 2 years outside of the US. Specialists for 3 weeks to 12 months. And teachers for up to 3 years. Individuals may repeat this visa after residing outside of the U.S. for 2 years. J-1 exchange visitors that are subject to the 2-year home country physical presence requirement may apply for a waiver. The waiver must be approved by the Department of Homeland Security before they can change status in the U.S. or receive a visa in a different category.
Some prospective H-1 workers are already on F-1 status. F-1 visas can be extended with further study. The visa category allows the beneficiary to work. What are some important things to know about F-1 visas, Jacqueline?
A prospective H-1B worker can remain in the U.S. on F-1 status if they pursue additional studies, such as a master's degree or PhD. Individuals are eligible to work for an off-campus employer directly related to their field of study, either under curricular practical training, CPT, or optional practical training, OPT. CPT must be required under the degree program, can accommodate full-time or part-time work, and can last for 12 months or more. However, working full-time under CPT for a total of 12 months or more may affect eligibility for OPT. OPT is available to F-1 students for up to 12 months after completing their studies. During the school year, individuals may work up to 20 hours per week on OPT if they have completed the requisite course of study. Certain individuals may also be eligible for a 24-month STEM OPT extension if they earned a degree in science, technology, engineering, or mathematics. They seek a training opportunity related to the degree, and they meet certain other requirements.
Certain employers are exempt from the H-1B cap. Which employers are these, Jacqueline?
Foreign nationals who are not selected in the H-1B lottery may consider seeking employment with cap-exempt employers, such as institutions of higher education, nonprofit organizations affiliated with an institution of higher education, and nonprofit or government research organizations. These organizations are not subject to the annual H-1B cap limitations, so they can sponsor H-1B workers without entering them into the lottery.
Thank you for that overview, Jacqueline.
You're welcome. For help exploring alternate visa options to the H-1B and maintaining status, contact your trusted Chugh LLP immigration professional.
Thanks for watching.